This is Bloomberg Law with June Grasso from Bloomberg Radio.
I'm grateful that the court ended the case against me, which was a prosecution based on malevolence and incompetence, and a reflection of what the Department of Justice has become under Donald Trump, which is heartbreaking. But I was also inspired by the example of the career people who refused to be part of this travesty. I know that Donald Trump will probably come after me again, and my attitude is going to be the same. I'm innocent, I am not afraid, and I believe in an independent federal judiciary.
Former FBI Director James Comey took a victory lap of sorts after a federal judge threw out the criminal charges against him and New York Attorney General Letitia James, ruling that the prosecutor who brought the cases had been illegally appointed. Lindsay Halligan was abruptly installed as the U.S. Attorney for the Eastern District of Virginia in September after her predecessor resigned under pressure to bring charges against Comey and James. Federal Judge Cameron McGowan Curry concluded that the Attorney General's attempt to install Halligan as interim U.S. Attorney was invalid. She dismissed the charges against Comey and James without prejudice, meaning that prosecutors may be able to refile the cases. In a statement, James said, "I am heartened by today's victory and grateful for the prayers and support I've received from around the country. I remain fearless in the face of these baseless charges as I continue fighting for New Yorkers every single day." The White House says it will appeal the decision. Here's Press Secretary Caroline Leavitt.
I know there was a judge who is clearly trying to shield Letitia James and James Comey from receiving accountability, and that's why they took this unprecedented action to throw away the indictments against these two individuals. But the Department of Justice will be appealing very soon, and it is our position that Lindsay Halligan is extremely qualified for this position, but more importantly, was legally appointed to it.
Joining me is constitutional law professor David Super of Georgetown Law. Explain why this judge, and this is the judge from South Carolina who was just considering the Lindsay Halligan appointment, explain why she dismissed the cases.
She dismissed the cases against Mr. Comey and Ms. James because she found that the U.S. attorney was not properly appointed. And since there was no one else in the room with the grand jury except Ms. Halligan, if Ms. Halligan had no powers, then no one presented the case to the grand jury, and it has to be dismissed in the judge's view.
So attorney generals have authority to name an interim U.S. attorney who can serve for 120 days. And the judge said that 120 days began when Halligan's predecessor, Eric Siebert, was appointed on January 21st, and when the clock expired on May 21st, so did the Attorney General's appointment authority. Is that a controversial interpretation?
It is controversial. The statute isn't terribly well written, but I think she follows most of the rules of statutory interpretation. And she says if the Attorney General can just keep reappointing people for additional 120-day slots, then why would the president ever bother to go to Congress for confirmations? And why is the statute even mention district courts, since presumably the Attorney General would take that power if it was there and would never let it fall to the district court? That's part of her reasoning. The other part of it that I think is also persuasive is that Congress changed this rule for about a year and then went back. So Congress had an arrangement where the Attorney General could appoint people for as long as she wanted, and they thought about it for a year and they said, no thanks, we don't want any more of that. So the judge asked quite reasonably, if Congress had allowed the arrangement that the Justice Department applies today and they changed the law to end it, why aren't we honoring Congress's decision?
So there have been judges in New Jersey and in Los Angeles who've come to the same conclusion about this 120-day rule. And the Alina Habba appointment to lead the New Jersey U.S. Attorney's Office is before the Third Circuit. If the Third Circuit comes down with a decision saying, no, this is okay, you can do this, does that have any effect on what happens here in the Fourth Circuit?
The Third Circuit doesn't have jurisdiction over this court. This court's appeals go to the Fourth Circuit. Obviously, a federal circuit court's views are influential, but the judge here does not seem to think this is a close case, and I tend to agree with her. So I think even if the administration wins the Alina Hobbit case, they're still going to have a real challenge on appeal in this case.
The substantive issues about vindictive prosecution and about what was said in the grand jury room by Lindsay Halligan that are before Judge Nachmanoff, does that go away now? Is that over?
If the government agreed to drop the case, then that stuff might be over. And on the principle that discretion is the better part of valor, that would be the smart thing for the administration to do. But given that the president has been tweeting instructions to get these people now, I have trouble believing that will happen. So I think that the vindictive prosecution matter is likely to go to decision because the government will appeal this thing. And if this decision is overturned, then whether it's a vindictive prosecution would come to the fore again.
So now they are going to appeal, no surprise. The White House spokesperson said the facts of the indictments against Comey and James have not changed, and this will not be the final word on this matter. So let's say they take it to the Fourth Circuit, and the Fourth Circuit affirms what the judge ruled here. So then they would go to the Supreme Court.
They would, and I'm sure this judge understands that and has peppered her opinion with citations to Justice Scalia, Justice Thomas, Justice Gorsuch, all the lions of conservative statutory interpretation. So the Supreme Court can reverse her only by reversing itself.
And I believe she also cited what was a controversial decision by Florida Judge Eileen Cannon dismissing the classified documents case against President Trump.
She did. I think that's a little gratuitous and less central to us, but she's got some basic statutory interpretation problems here, and she is hewing very closely to the procedures the Supreme Court has said, and hardly takes a move without citing a Supreme Court statutory interpretation case. I teach statutory interpretation, and I will be likely assigning this case because it's such a nice summary of all the moves you're supposed to make.
Next stop, Fourth Circuit, I'm sure. Thanks so much, David. That's Professor David Super of Georgetown Law. Coming up next on the Bloomberg Law Show, a global insider trading case that sounds like a movie script. I'm June Grasso, and you're listening to Bloomberg. The global insider trading ring allegedly started at a meal at a Paris restaurant owned by an ex-Merrill Lynch investment banker, with members using burner phones, coded language, and encrypted messaging apps to conceal its activity, and payments for insider tips being made using cash transfers, shell companies, fake invoices, and even a plastic bag stuffed with 100,000 euros in a Vienna cafe. And prosecutors say the ring raked in more than $17 million from a staggering number of insider tips on more than 15 deal targets. My guest is former federal prosecutor Stephen Frank, a partner at Quinn Emanuel. This global insider trading ring sounds a little like a movie script at some points.
It does sound like a movie script, and that's because it is a lot like a movie script. What this case is about really is an incredibly sophisticated, long-running, worldwide insider trading scheme involving insiders at a number of different companies, and they haven't actually been charged yet, along with a web of traders all around the world who are exchanging messages and exchanging inside information in incredibly difficult to detect ways, sometimes in person, sometimes over encrypted apps, often using burner phones with SIM cards that they are swapping regularly, and laundering the funds through complicated transactions, sometimes in cash, sometimes using a variety of bank accounts, sometimes sending cash through the mail, often disguised as gifts or other types of things. And so it's been able to survive all these years, in part because there are so many different traders involved. The information is being dispersed so far and wide that it's incredibly difficult to trace.
Did it go for almost 10 years?
Something like that. I mean, it's been going for a number of years. I think it's hard to discern exactly how long it's been going on. We can sort of trace when the initial contact between certain of the players happened, but I don't think we know the initial origins of the entire scheme.
Were there specific, types of trades that they shared inside information on, or was it a variety?
It was a variety. It was in different industries. It was in all different types of companies, some that trade in the U.S., some that don't. And that's what also made it so difficult to detect, but also kind of what gives it away, right? It's clear that there is no one insider at any one company who's sharing this information. It's clear that there are insiders at a variety of different companies who are sharing information. That's almost unprecedented in these types of schemes. Insider trading traditionally was, a tip passed, over a glass of wine or a beer at a country club or on a golf course in a single company at a single time. It's unusual to have cases where there's different iterations of information being passed over time. It's still far more unusual to have so many different companies where information is being passed and over such an extended period of time with so many different traders involved. That's what's really quite fascinating about this scheme.
Is there any indication how the authorities first got wind of this?
Well, I should tell you, I was involved in the original investigation and then handed it off when I left the government to go into private practice. So the way that the authorities, first got involved in this, sort of first figured out that something was amiss, is simply by seeing the repeated, trading in certain companies. There was one company in particular where various subsidiaries of the company were involved in transactions over time, and there was trading ahead of those transactions that was suspicious. But really what happened was you had certain individuals who kept popping up on the radar of law enforcement and of international securities regulators, and law enforcement and regulators looked closely at those individuals, looked closely at their transactions, their financial transactions, and put this together over many years of investigation through just painstaking investigative work. I mean, the amount of investigation that goes into an indictment like this is pretty incredible, and it involves sophisticated techniques like, search warrants for electronic accounts, for email accounts, for Facebook accounts, for iCloud accounts, and then sifting through all of that information in a painstaking way, much of it not in English, and putting little pieces together over time. But it was really the result of incredible collaboration between U.S. law enforcement and regulators in the United States, as well as regulators and law enforcement in England, in France, and in other countries.
So I was going to ask, how much that complicates the investigation when you're dealing, with other countries and with things happening abroad.
It makes it incredibly complicated, and that's why these schemes are able to persist, because they know that and they take advantage of that. No one country can put a case like this together all by itself. It really requires collaboration among different law enforcement and regulatory authorities with different mandates, different evidentiary rules, different procedural rules, and then figuring out how to share that information in ways that it can be used by different countries. I mean, even just the fact that there are different time zones involved makes things complicated and really requires people to work off hours, to work around the clock, to travel internationally, just to gather the bits and pieces of evidence that's required to put a case like this together. It's extremely complicated.
Is there competition? I read that French investigators have been conducting a parallel investigation for years. Is there competition among the regulators of the different countries to bring the indictments first?
That's a great question. There is some of that, and there's certainly a desire by regulators and law enforcement in each country to be the first to put the biggest case together. But ultimately, there's also a recognition that this is a big enough scheme. It's sprawling enough that there's something in it for everybody, and there's more than any one country can do on its own. So it's ultimately figuring out what makes the most sense in dividing up the pie. One of the things that U.S. law enforcement has as an advantage is that sentencing here for these types of crimes is substantially greater than it is in most other countries, and in Europe in particular. And so ultimately, what all regulators, whatever country they're in, want to do is take down these types of schemes that are really taking advantage of innocent investors and making markets an unlevel playing field, right? I mean, ultimately, if investors don't have confidence in the securities markets, they're not going to invest. And that's true in the United States, but it's also true in France, and it's also true in England. So ultimately, their regulators realize that if they're able to cooperate and come down with a heavy hand on schemes like this and make it clear that however much profit insider trading might generate in the short term, in the long run, it's going to put you behind bars for an extended period of time. That's in everybody's best interest because that protects markets here, but it also protects markets over there.
When administrations change and priorities of administrations change in enforcement actions, do some investigations fall by the wayside, and why did this one not fall by the wayside?
Well, a couple of things. I'll say this one was in a pretty advanced state by the time the administrations changed over. But also, it's pretty clear that in this administration, as in past administrations, securities fraud and insider trading remains a point of focus. So if you look at the statistics over the past year of this administration, what you'll see is that while white-collar crime enforcement in general is down, there are fewer cases being brought. And on the SEC side as well, there are fewer enforcement actions being brought, particularly against corporate actors. Securities fraud, and in particular insider trading cases, have held steady and perhaps even trended up a little bit. And that's because I think Chairman Atkins and others in the administration see crimes against the markets and crimes against individual investors as crimes they really need to pursue, because of the reasons I just said, because it undermines confidence in the markets. And one thing that this administration has in common with prior administrations is they want the markets to remain strong and investors to have confidence in them. And that's why we've seen pretty rigorous enforcement and a number of cases being brought against insider trading schemes over the past year. And not every scheme, obviously, is as complicated as this one. This one is really unprecedented in its sweep and sophistication. But we've seen cases across the United States, really, against just ordinary insider trading schemes, the types of one-off schemes I was talking about a moment ago, where information is being passed, on a cocktail napkin across a bar, or even insiders trading in their own companies, which is the least sophisticated kind of scheme. Finding out information that's not public that can move a stock in your own company and trading on it either in your own account or in the account of a friend or a relative. Those are relatively easy to discover, and they're surprisingly commonplace.
It sounds like this might be a tough case to try to put this all together for a jury. What do you think is the strongest evidence that the prosecution has?
Well, if you read the superseding indictment in this case, the prosecution has really put together a pretty compelling case, replete with very devastating text messages, really text messages that are going to be difficult for the defendants to explain, in which they're speaking in code, but it's a barely disguised code. They're talking about swapping phones and SIM cards as socks and shoes. They're talking about money as greens. They talk about financial transactions sometimes as meat put in a refrigerator. It's almost comical the way that they use this code, but ultimately, when you put all of these conversations together, it really becomes pretty compelling. And then when you combine those with the cash, the financial transactions, and the stock trading, it really becomes overwhelming. What's interesting about this indictment is it was unsealed, even though many of these players have not yet been arrested. So one individual was arrested and extradited to the United States. Another individual is in Singapore and is fighting extradition. Other individuals have been charged and named, but not yet arrested or extradited to the United States. Now, those individuals are going to find their ability to travel freely severely constrained, and many of them probably will be picked up over time. But that doesn't mean that the evidence about them doesn't come in, because this is charged as a conspiracy. And in the U.S. legal system, evidence of communications among conspirators in furtherance of a conspiratorial aim can all come in. So all of this evidence about all of the different players in this conspiracy is going to be admissible for prosecutors if and when this proceeds to trial. The
prosecution has a cooperator. How important is his testimony?
It's always important, particularly when you have these types of coded communications, for a cooperating witness to be able to get up on the stand and say, this is what we were talking about. This is the terminology that we used. These are the types of techniques that we used to hide our communications, make them more difficult to discover. The most compelling thing, though, about any cooperating witness is the fact that he's going to get up there in all likelihood and say, I committed this crime. I was a part of this scheme. This was a conspiracy, and the defendant was in it with me. That's really devastating evidence that's very difficult to undermine, particularly when that individual has accepted responsibility for their own crimes.
Do you envision the prosecution sort of presenting this like a movie, like here we are at the French restaurant and blah, 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 blah?
It is pretty cinematic. So if they're smart about it, and they are, and I'm sure they'll do this, they will present it in that way. They will have, first of all, these communications are so devastating, they're going to be put up on a screen. And even though there's no audio of these communications, there wasn't a wiretap involved in this case, you'll nevertheless be able to see these communications and play out these transactions almost in real time. And then you'll have it narrated by somebody like this cooperating witness who's going to be able to say, I was there and I was passing this cash, in a paper bag or whatever the case may be. And it's really captivating for jurors. I've, been on cases similar to this before, where jurors have said afterwards that they were really just so enthralled by the presentation of the evidence, because it really is, even though these are just financial transactions, the level of greed involved and the lengths that people will go to disguise these transactions is pretty incredible.
You were a prosecutor for a long time. Now you're on the other side. I mean, do you see a possible defense here?
It's going to be interesting. I mean, I think any defense attorney is going to, do some basic things. One is you're going to try and keep out as much evidence as you possibly can, right? Go after the search warrants and try to figure out some way, legal or otherwise, that they are invalid. Another thing is obviously, attack the cooperating witness, try to undermine the credibility of the cooperator and suggest that they're doing it really to obtain leniency in their own sentencing, but that they are really just telling a story that the prosecution wants them to tell. Another piece of it is to point to the empty chair, right? To say that there are all these other players involved, but where are they? And try and undermine the case that way. But when you have a case that's been put together over years with as much evidence as it appears the prosecutors have in this case, it's tough. And sometimes defendants take their shot because they figure they have nothing to lose, but other times they try to work out a deal. And no doubt, given the number of people who still haven't been apprehended and the number of others who are undoubtedly involved in the scheme and haven't even been charged, including the insiders at some of these companies, there's going to be a real incentive as the trial date approaches for some of these people to flip themselves and try and work out a deal for themselves.
It seems like this would be a great trial to watch.
It's a really cool case. It's a pretty unprecedented case. It's unusual for a case like this to be brought in a place like Boston, which isn't, as big a financial center as New York or even San Francisco. But it's really a testament to the work of, individual prosecutors and FBI agents and folks at the SEC to put a case like this together. I mean, the amount of work is really, it's not apparent at first glance, but it's literally years of work.
It's been a fascinating conversation. Thanks so much. That's former federal prosecutor Stephen Frank, a partner at Quinn Emanuel. The Securities and Exchange Commission is dropping its landmark lawsuit against SolarWinds that accused the company of covering up internal problems ahead of a massive cyber attack. The agency said the decision to seek dismissal is, quote, in the exercise of its discretion and does not necessarily reflect the Commission's position on any other case. The move ends a controversial case for the SEC, which faced criticism from Wall Street and beyond that its allegations against SolarWinds went far afield of the agency's typical enforcement remit. My guest is securities law expert James Park, a professor at UCLA Law School. Jim, tell us about the SEC suit.
This is a major cybersecurity disclosure case involving a company in Austin that developed network monitoring software, basically software that you use to monitor the performance of your network. And obviously, for software like this, cybersecurity is very important because somebody could come in and see everything that's going on in your network. And they have a major cyber attack on something called their Orion software platform that generated almost half of their revenue. Their stock price goes down, and then the SEC brings a case saying that various disclosures they made with respect to their cybersecurity practices were materially misleading. That was litigated by the company, which does not always happen. A lot of defendants settle SEC cases rather than pursue dismissal, but they litigated in the Southern District of New York. Judge Engelmeyer dismissed part of the SEC's claims, not all of them, but some of them. And this was about a year or so ago, and then we just got news last week that the SEC has chosen not to go forward with the case.
I mean, did this case diverge in any way from a normal or the usual SEC enforcement actions?
One way it diverged, I think, is the defendant litigated the case. And, another is that, when you bring a major case like this, you usually pursue it to the end. And I think that's usually the practice with the SEC. Even when the administration changes, you have enforcement cases that often are left over from prior years because they take a long time to resolve. And then the enforcement staff they continue to litigate those cases, even if there might be some disagreement with the new commission. And so it is a bit unusual, though not unprecedented, for the SEC to stop pursuing a case. Of course, this did happen as well with the various crypto enforcement cases. So for this SEC, it's not unprecedented. For prior SECs, I think it's unusual. I think that would be fair to say.
So, and also, is it the first time they sued a computer security executive for a cybersecurity related issue? The company said that they were trying to expand their turf.
That is unusual, right? The chief information security officer who, it's not the CEO, it's not the chief financial officer, and I don't know if they've ever sued a chief information security officer before, but this is certainly something that was relatively new. And so that was another, interesting aspect of the case.
Why did the judge dismiss a lot of the case?
I think one reason was that some of the statements the SEC alleged were misleading were these broad statements about there's a risk of cybersecurity breach. And these are the types of disclosures that are made by a lot of companies. And what the SEC was saying is that the reason those generic disclosures were misleading is that they were never really updated, even when it became clear to the company that its cybersecurity was insufficient. And so the SEC was saying that you basically were putting out this generic disclosure to keep investors satisfied, but you were not updating it when new developments came along, and investors would want you to update those risk disclosures. And really what the judge said was, well, the risk disclosures, they were enough to tell the investors that this was a type of risk. And investors, they understand that companies talk in generalities like this. There's a doctrine called the puffery doctrine where everyone understands companies are always going to try to put a rosy tone on things, and they speak in a very optimistic way. So they do this, and investors know this, and they know that they shouldn't trust these broad statements on face value. And so that was the main reason a good chunk of the case was dismissed. Now, there were statements that were more specific that were published on the company's website, which the judge said could proceed. The claims could proceed because they made much more specific statements that the company was using strong cybersecurity, that they had gone through a rigorous development process, that they were very sort of diligent in evaluating their internal cybersecurity controls, and those statements might have been misleading, according to Judge Engelmeyer.
Why do you think the SEC caved here?
I think that cybersecurity has been controversial in terms of whether this is an area where the SEC should be significantly involved. And it's only been fairly recently that we think of cybersecurity as something that the high-level managers of the company must be really vigilant about. I think there was a time when we thought of cybersecurity issues as being, this is what the IT department is responsible for. It's not something that the board really should be knowledgeable about, because the board, quite frankly, doesn't have the expertise in evaluating a company's cybersecurity. And so there's been a big shift, though, to require disclosure about cybersecurity and to require the board to evaluate the adequacy of cybersecurity. I think that's been controversial, although I think it still is an expectation. And, in addition to cybersecurity efforts being generally controversial, I think enforcement relating to cybersecurity disclosures might have been even more controversial, because the critics would say, basically this is a company that was a victim of a cyber attack, and so they were victims, and now you're saying that they should also pay for misleading investors. And so there might be something off-putting or problematic about saying that, well, you were the victim of the cyber attack, plus you also have to pay money to your investors because you didn't stop it. I think that's kind of the argument here, is that, it's almost punishing you twice for being the victim of a cyber attack. Now, on the other hand, you could say, well, this is a company where cybersecurity matters a lot, and so they should have made more timely disclosures. That's the argument on the other side, but I think that may be what the SEC was thinking here, is that we want to pull back a bit on cybersecurity enforcement.
So officially, the SEC said that the decision to seek dismissal is in the exercise of its discretion, does not necessarily reflect the Commission's position on any other case. I mean, do you think the SEC intends to continue to focus on cybersecurity, or this case says no?
Well, it's a powerful statement, but I think the SEC may be leaving some room to change its mind, and if there are a better set of facts around that they might find. And so I think they are leaving open the option to bring enforcement cases, and they're not saying that, that you can't sort of violate securities fraud provisions through misstatements about cybersecurity, but I think they're saying in this case maybe the case was not as strong as it could have been. And I think it's a powerful signal with respect to this particular SEC.
I guess chief information security officers are breathing a sigh of relief with this, because it would have meant personal liability.
Yeah, I think that's right. I think there definitely is potential for liability. Of course, if they settle, the payment may be covered by an insurance policy, but it's never easy when you are specifically named in a complaint. And, I think if you're the CFO, you fully understand that this is something that could happen. Chief Information Security Officer, maybe not. But, this also speaks, though, to the difficulty of bringing cases against individual corporate officers, which the SEC says it wants to do more of. But, when you single out a particular individual, there is sometimes a question of, is it fair to put so much blame on a single person when, it might have been more of a systematic problem at the corporation. that the high-level officer may not have really had complete control over. So I think that's an interesting point, is that in some ways this kind of acknowledges that it's actually really hard to build cases against individuals, and sometimes you may seem unfair.
Any final thoughts, Jim?
I think you might think of these cybersecurity cases as just another form of a type of case that is commonly brought, which is that there's some business development that the company knows about, some business failure. We have a product we thought was going to be great, but we know it's going to be delayed a long time. It has a lot of flaws in it, and we don't tell investors. I think it's fairly clear now, based on 30, 40 years of case law, that lying about business developments can violate securities fraud laws. And there's an argument that if you are lying about the strength of your cybersecurity controls, that's not all that different, right? Because it's not a business failure, but it is a failure in what you're supposed to be doing to protect your customers, to protect investors. And so these disclosures can be important. And I don't think the SEC's direction in this was completely unfounded, because I think, disclosures in business practices relating to treatment of customers and so forth are pretty relevant to what investors are looking at for companies like this. I do agree, though, that it is difficult to sort of determine when exactly was it clear that they were engaging in really, really risky behaviors that were so far below the industry norm that we would want them to be accountable for not saying more about their vulnerability to a cyber attack. I think that's a really difficult question to answer as well.
Thanks so much, Jim, as always. That's Professor James Park of UCLA Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.